Here are the top 10 reasons why your fiancé visa could be denied. Reason 1. Your fiancé has violated the terms of his or her US visa in the past. Among other things, overstaying a US visa by more than 180 days can cause your fiancé to not be able to obtain a fiancé visa or be able to come to the US at all for 3 years or 10 years if the overstay was over 1 year. Reason 2. The US citizen is not able to financially support his or her fiancé. The US citizen must show the US government that he or she makes 100% of the federal poverty level for his or her new family size for a fiancé visa case. You can use cash, bank accounts, or assets to also help you meet this requirement if you do not make enough at your job. Also, most embassies will let you use a financial co-sponsor. Reason 3. Either the US citizen or his or her fiancé has past criminal issues. Any past criminal matter should be evaluated by an attorney prior to filing to make sure it will not cause the fiancé visa case to be denied. If the US citizen does not qualify to obtain a fiancé visa, then the marriage green card, while the fiancé is abroad, should be explored. The last thing you would want to do is file a case that has very little chance of being approved and waste the time involved in having USCIS deny your case. It is far better to take the time to resolve any issues prior to filing anything with USCIS. Reason 4. One of you is not free to marry. A fiancé visa case will be denied if it is filed before you are legally divorced. Prior to filing, you should make absolutely sure that all previous marriages for both parties are completely terminated. This means that all prior marriages have terminated either by death, divorce, or annulment. There are plenty of people who believe that they are legally divorced when, in fact, their divorce has not been finalized. If you're unsure if your divorce is final, you should consult with a family law attorney in the state where your divorce was filed. Reason 5. It has been more than 2 years since you last saw your fiancé in person. Seeing someone on Skype does not count as an in-person meeting. Keep receipts, plane tickets, and other evidence of any in-person meetings you have with your fiancé. You may be able to have this requirement waived based on medical or religious reasons. Reason 6. The paperwork you provided USCIS is incomplete. You should be given a request for evidence to correct this type of problem. If you do, you need to timely provide this requested information or your case will be denied. It is also possible that USCIS will simply deny your case if you're missing a given document. If this occurs, you will have to refile your case and repay the filing fees. Reason 7. Not telling the truth on your paperwork. Lying or misleading USCIS on paperwork can lead to denial and other very serious long-term consequences. Simply do not do it. If you believe you have a reason to lie in your case, speak to an immigration attorney. Many times, things that you believe will cause you problems in your case are not big problems and can simply be corrected prior to filing. Reason 8. Your fiancé has a medical condition which could threaten public safety or is mentally ill or has a drug or alcohol problem. These things should be evaluated by an attorney prior to filing your fiancé visa case. Reason 9. The consular office has reason to believe that the relationship is not real. This includes, but is not limited to, a large age difference between the parties, limited visits between the parties, different religions, not speaking the same language, not complying with cultural norms of the fiancé's country, or there being a short amount of time from the time of meeting to the time of applying for the fiancé visa. Reason 10. Your fiancé has a bad interview. This is a big reason. Your fiancé should know a lot about you in order to have a good interview. It may be embarrassing to you, but tell her about yourself, your current economic situation, job, living situation, etc., your past relationships, and any criminal history. If something is brought up about you at the interview, your fiancé should know about it. Not knowing important facts about you is a serious red flag to USCIS. You should go over your fiancé visa interview questions with your fiancé prior to his or her interview. Your fiancé should also bring plenty of evidence proving your relationship to the interview. If you found this video helpful, please give us a like and also feel free to email us about your immigration case. You can contact us at attorneygruner@gmail.com. Our email correspondence is free and confidential. We would be happy to answer your questions. This video is for educational purposes only and should not be relied on for legal advice. We do not represent you. Always consult with an attorney prior to filing paperwork or doing any immigration-related activity.